I know we get this question at the firm all the time, we get calls about it often, and it's do grandparents have legal rights to grandkids in the state of Wisconsin?
So the short answer is yes. There is an avenue through the courts by which you can assert grandparents' rights and actually get an order for visitation. The long answer is that though it is provided for under statute, it's very difficult to effectuate in practice. And there's a number of reasons for that, but primarily it's because we respect the family unit and the biological parents' rights to raise their children as they see fit. And so oftentimes you will see grandparents try to assert this right in an intact marriage where the parents have essentially excluded grandparents that were previously involved with the family unit, and now there's a family rift of some sort. In those situations, it's extraordinarily difficult to pierce that family unit and force upon the family a grandparent visitation order. However, more often the case is that a grandparent will come to us requesting that we file for grandparent visitation because their biological tie to those grandchildren has now been disrupted in some way, either through divorce and their biological tie didn't receive much placement in the court system, or through death or incarceration or other types of incapacitation. So for instance, if someone had some mental trauma and they weren't competent now to provide care for their children, then grandparents might initiate an action with the court in order to get some placement time carved out. There are standards that have to be met in order to do so and be successful in getting that order. And typically you have to not only be able to establish the fact that you were involved in that child's life to the extent that you established a parental role. There needs to be a substantial bond and a course of conduct of ongoing and consistent involvement with the grandchildren in order for the court to acknowledge that you have a right that should supersede the parents' rights to say no. In addition, you have to show that the parent who has the authority to provide that visitation is somehow frustrating that. So if the biological parent that has placement is allowing you to see them at reasonable times, say for holidays, or will bring them over for birthdays, or invites you to family gatherings, as long as they're still facilitating a relationship, it'll be very difficult for you to meet that standard of proof in order to assert that a schedule needs to be in place and that you need to be acknowledged as an interested party outside of the biological parents.
So under a scenario where maybe a grandparent was the day-to-day provider because the parents, couldn't afford daycare, or maybe it was even a better option because it was a grandparent, so every day the child was with that grandparent for 3 to 5 hours in the morning, say, would that be a scenario where that might be something that they could be a relevant scenario where that grandparent could try to assert rights?
Yes, absolutely. That's precisely the type of scenario that we're talking about. Regular and consistent bond with the child that now has been disrupted unilaterally without cause.
So kind of the inverse of that question, and you touched on it a little bit, is can a parent deny a grandparent visitation?
Yes, absolutely. As I indicated before, the presumption is that biological parents are in the best position possible to determine what's in the best interest of their children and raise them within the family unit. And as you can imagine, we don't want to trample upon that right for a number of reasons. And the one that I most frequently give to grandparents that come to me with this question is that I'm certainly not saying that's happening here, but you can imagine that our legislature wants to protect grandchildren and give biological parents the credence and authority to make decisions related to their own parents who may, when they were children, have had an abusive relationship. We don't want to put children in a position where they're going to be at risk. And so asserting that a grandparent would have a right that trumps a parent would actually potentially perpetuate abusive situations. And so when we're safeguarding children against that, we have to be very heavy-handed in how we apply the law and what those very limited situations look like where we are going to supersede a biological parent's right to protect their children. So, certainly there is an ability to exclude grandparents from visitation with your children. The difference is that when you have allowed a grandparent to have an active role in your child's life and child rearing in particular, and then you unilaterally, without cause, revoke that involvement. The courts will acknowledge that having additional loving and supporting adults in a child's life is certainly in their best interest, and the removal of a loving and supportive party is detrimental to a child. And so in those cases, absolutely, we have a process through which grandparents can assert their right for visitation, but generally speaking, it's left to the biological parent to determine what's in their child's best interest.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.